Hello everyone, welcome back to our channel. I am SURBHI GOYAL and legal intern at LEXCLIQ. Today's topic is Indian Forest Act 1927. So let's start from the introduction. So, forests are one of the essential natural resources available in the country and cover around approximately one-third of the Earth's total area. The word forest is derived from a Latin word foris, meaning outside. The forests act as a guardian and protector of the wildlife of the country. Its use as many in terms of fertility, shelter to animals, as well as type of population. To mention a few, which in turn helps to maintain the ecological balance all over the country. Forests are a means of generating revenue from the state by supplying various raw materials in its most natural form to the industries globally. They are a reason behind climate change and in controlling the quality of air and water. So, the forests are in use in the hands of the majority population in due to which the resources available are being consumed at an alarming rate resulting in depletion. The users of the forest have recklessly utilized the forest for cultivation and destroyed them in the name of agriculture and other personal, you can say, consumption of food, of wood, timber, fuel, and fodder. The need for a legislation protecting and regulating the forest was required, which was made by the Indian Forest Act 1927, imposing governmental control over forests by classifying them into reserve. So, protected and village forest. The Act of 1927 is a comprehensive legislation incorporating all the pre-existing laws enacted to protect the forest as well as the rights of the people residing in the forests. The first legislation was enacted in 1865 during the British rule, which was an attempt to protect the forest of the act. It's had its fallouts with relation to the right of the people that were not protected. The amendment of 1878 was aimed at improving the deficiency of the Indian Forest Act 1865. So now let's talk about the Indian Forest Act 1927. In 1927, a revised legislation of the Indian Forest Act was enacted based on previous Indian Forest Act implemented under the British. Just like the preamble to the Constitution that lays down the objectives, every legislation has its preamble wherein the objectives and guidelines of the particular act are listed. The preamble of the Indian Forest Act seeks first to consolidate the law relating to the forest, second, regulation of and the transit of forest produce, and third, to levy duty on timber and other forest produce. It also consists of the procedure followed in cases of declaring the area to be reserved, protected, or a village forest. The Act is divided into 13 chapters with a total of 86 sections, ranging from the definition of various forests to the penalties that are to be levied on the violation of the provision of the Act. The term forest has a wider ambit when it comes to its definition, and it includes private lands, land of pasture, cultivable land, etc. And so that the Supreme Court is yet assigned a particular interpretation, and thus the Act is silent on the definition of a forest or a forest land. So the section 2 of the Act, that is the interpretation clause, defines various terms that are essential in the domain of forests, starting from cattle, inclusive of all the animals, the forest officer who is made in charge by the state government, the forest produce, which include timber, charcoal, wood oil, etc. It also has a separate interpretation of the river, including any stream, canal, or other channels. Further, the Act is classified into three types of forest that are reserve forest, protected forest, and village forest. So we'll talk about these type of forest in the upcoming in the above minutes. So, first type of forest, reserve forest. The reserve forests are dealt in chapter 2 of the Act, ranging from section 3 to 27. In simple words, any forest land of wasteland to which the government has the ownership is a reserve forest. These forests are restricted as the government has proprietary rights over the land. The use of the reserve forest is prohibited to the local people unless they have a permission by the government. The area of land is declared to be a reserve forest when the government issues a preliminary notification under Section 4 of the Act declaring such a land is to be constituted as a reserve forest, and the forest settlement officer settles all the rights either by admitting or rejecting them. Section 26 of IFA 1927 deals with the prohibition of a number of activities including grazing, tree felling, burning, quarrying, hunting, etc. In the forest, the penalty of the violation of the provision of Section 26 or imprisonment of a term which may extend to 2 years or with which may extend to rupees 20,000, but with small not which will not be with less than rupees 5,000. So next type is village forest. We all know, following the order of the section under this act, the village forests are dealt with the next in chapter 3 of the act under section 28. When the government assigns any reserve forest or any other land to the village community for the use, that piece of land is classified under the village forest lands. As according to the act, the state government makes rules for the regulating the management of these forests. The term village forest and forest village are interchangeably used in certain cases, but are eventually different in their meaning. While village forest is a legal category under the Indian Forest Act, forest village is merely an administration category, although the latter is recognized by the forest department. The revenue benefits cannot accrue to such villages as they are not technically under the revenue departments. Generally, the land given to village forests are constituted to village grazing reserves. Next type of forest is protected forest. So the state government is empowered to constitute any land other than the reserve forest are protected forest, over which the government has proprietary rights. The provisions for the protected forests are dealt in chapter 4 under section 29 of the act. In the case of these forests, the government retains the power to issue rules regarding the use of forests, and in cases where there are no rules, the practices are allowed. Along with the rights, the government also has the power to reserve the specific tree species in the protected forest. The sole reason behind this being that those particular trees have the revenue raising potential and are thus required to protect it for the benefits of the economy. Chapter 5 of the Act deal with another type of forest named non-government forest and rather private forest, considering the other forests to be owned and regulated by the government. These forest lands are not in control of the government, though the state government can be by notification prohibit and regulate the clearing of land for various purposes, which comes under the government power on only in special circumstances, like to preserve public health and wellness. Now I will come to the conclusion. The Indian Forest Act 1927 is a revised comprehensive legislation enacted with the intention to deal with the LECNE in the previous act and formulate the laws of the forest. Though the act has attempted to classify the forest and protect their extensive use, it has eventually failed by providing sole decision-making authority in the hands of the government, making the legislation arbitrary and unreasonable in its use. Although the Act aimed toward the forest conservation and its forest produce duties, it failed miserably in meeting its objective. The essence of the Act was not when the government regained the control of these forests so that the revenue can be generated from the forest produce. Eventually, the Act could not serve its purpose, that is to be avoid the explanation, as earlier the people were exploiting the forest and now it was the government in power to regulate and prohibit the uses of the lands. So that's all for today. I hope you like the video and do subscribe to the channel. Thank you so much. Have a nice day.